Did you know that thousands of California landlords are facing unexpected lawsuits, frozen rent increases, and fines reaching tens of thousands of dollars? Not because they were bad landlords, but because they didn't realize the rules had quietly changed? What's even more shocking is that many of these penalties are being triggered by simple paperwork mistakes, delayed repairs, or communication errors that landlords have been making for years without consequences. But in 2026, enforcement is different. Tenants are more informed, local governments are stricter, and legal protections have expanded in ways that are catching property owners completely off guard. Imagine waking up to a legal notice, a complaint, or a demand for compensation, all because of something you thought was normal landlord practice. That fear is becoming very real. Some landlords are losing months of rent, while others are dealing with lawsuits that could financially drain their investment property. In this video, we're breaking down 10 powerful new landlord rules you simply cannot ignore. And the final one could protect you from a devastating financial mistake. If protecting your property and income matters to you, like this video, subscribe to the channel, and comment where you're watching from. Number 10. Insurance, liability, and lawsuit exposure. One of the most dangerous mistakes California landlords are making in 2026 is assuming their insurance automatically protects them from every tenant dispute, injury claim, or compliance violation. The reality is far more unsettling. Many landlord insurance policies contain hidden exclusions that can leave property owners financially exposed if a lawsuit is connected to negligence, delayed maintenance, habitability complaints, or even improper eviction procedures. That means a single tenant injury, mold allegation, or harassment claim could bypass insurance coverage entirely, forcing landlords to pay legal fees, settlements, and damages out of pocket. What makes this even more alarming is that lawsuits are increasing as tenants become more aware of their rights and legal support becomes easier to access. Another overlooked risk involves liability gaps between property insurance, umbrella policies, and personal assets. Some landlords believe their LLC structure alone protects them, but legal experts warn that poor documentation, direct landlord involvement, or failure to follow compliance procedures can weaken that protection. In certain cases, tenants are successfully pursuing claims that extend beyond property coverage, especially when safety complaints, security issues, or privacy violations are involved. The financial impact can escalate quickly, not just through compensation payments, but also through attorney costs, court fees, and prolonged rental income loss during disputes. The smartest move landlords can make right now is conducting a full insurance and liability review. This includes verifying habitability coverage, checking legal defense provisions, strengthening documentation practices, and considering umbrella liability policies for additional protection. Proactive compliance, clear maintenance records, and professional communication can dramatically reduce lawsuit risk before insurance is even needed. If you want to protect your investment from the kind of legal surprises that devastate landlords financially, start treating liability prevention as seriously as rent collection. Number 9. Discrimination and application. Screening risks. A growing number of California landlords are discovering that tenant screening has become one of the highest legal risk areas in property management, even when there is no intention to discriminate. In 2026, enforcement around fair housing practices is tighter, and what landlords consider normal screening, credit checks, income requirements, background reviews, or even communication tone, can sometimes trigger discrimination complaints if the process appears inconsistent or lacks transparency. The most concerning part is that many violations are not obvious. A rejected applicant may claim unfair treatment based on protected characteristics and without clear documentation showing objective decision-making, and landlords can find themselves defending costly legal complaints that drain both time and money. Another major risk comes from informal or inconsistent screening practices. Approving one applicant with flexible income verification while rejecting another under stricter standards can appear discriminatory, even if the decision wasn't intentional. Additionally, automated screening tools and third-party tenant reports are creating new concerns as landlords remain legally responsible for how screening data is used. Mistakes in background interpretation, outdated criminal history checks, or overly strict occupancy limits can all become legal vulnerabilities. With tenant advocacy groups actively educating renters about their rights, screening decisions are being challenged more frequently than many landlords expect. To reduce exposure, landlords should focus on standardized written screening criteria applied equally to every applicant. This includes clearly defined income thresholds, transparent credit expectations, documented reasons for denial, and proper adverse action notices when applications are rejected. Keeping communication professional and avoiding subjective comments can also prevent misunderstandings that escalate into complaints. Ultimately, the safest approach is consistency. When screening decisions are objective, documented, and legally aligned, landlords not only protect themselves from discrimination claims, but also create a smoother, more professional leasing process that reduces stress and legal uncertainty. Number 8. Short-term rental and subleasing restrictions. Many California landlords are being caught off guard by the rapid expansion of short-term rental and subleasing restrictions, especially as cities tighten rules around platforms like Airbnb and unauthorized tenant arrangements. What used to feel like a tenant's harmless side hustle can now create serious legal and financial consequences for property owners. In some areas, landlords may face fines, permit violations, insurance complications, or even lease enforcement challenges if tenants list units for short-term stays without proper approval. The biggest problem is that landlords often discover these situations only after neighbors complain, building management reports unusual activity, or local authorities issue warnings. By then, the landlord may already be exposed to liability risks tied to zoning rules, occupancy limits, or safety compliance violations involving temporary guests. Subleasing also presents hidden dangers when tenants bring in additional occupants without notifying the landlord. Overcrowding, increased property wear, safety concerns, and conflicts with building regulations can quickly escalate into lease violations that are difficult to resolve. Even worse, unauthorized occupants may create legal gray areas regarding eviction rights, rent responsibility, and liability if damages or injuries occur. Some landlords are surprised to learn that failing to address unauthorized subleasing early can weaken their position during disputes, making enforcement slower and more complicated. With housing costs rising, more tenants are turning to subleasing as a financial survival strategy, meaning this issue is becoming far more common than many property owners realize. The safest approach is proactive prevention through clear lease clauses, regular communication, and monitoring unusual rental activity. Landlords should explicitly outline short-term rental policies, require written approval for subleasing, and stay informed about city-level regulations that may impose additional restrictions. Addressing concerns early protects both property condition and legal standing. If you want to stay ahead of costly surprises like this video, subscribe to the channel and comment if you've ever dealt with unauthorized subleasing or short-term rental issues. Your experience could help other landlords avoid serious mistakes. Number 7. Local ordinance and city-level rule. Conflicts. One of the most confusing challenges California landlords face today is the growing conflict between state housing laws and city-level ordinances, creating a legal maze that can easily lead to accidental violations. Many landlords assume that following statewide rules automatically keeps them compliant, but in reality, cities often introduce stricter regulations covering rent control, eviction procedures, relocation assistance, inspection requirements, and tenant protections. This means a decision that appears completely legal under state law may still trigger penalties at the local level. The real danger is that these conflicts are not always obvious, and landlords frequently discover them only after receiving notices, complaints, or enforcement warnings from local housing authorities. Another complication is the constant evolution of municipal rules. Cities may update policies faster than landlords can track them, especially in areas experiencing housing shortages or increased tenant advocacy. Requirements related to notice periods, rent increase limitations, registration programs, and tenant relocation payments can vary dramatically between neighboring cities, leaving landlords vulnerable when they rely on outdated information or general assumptions. Property owners managing units across multiple locations face even greater risk, as compliance strategies that work in one city may be completely inappropriate in another. These inconsistencies can delay evictions, invalidate notices, or create financial obligations that landlords never anticipated when purchasing the property. To navigate this environment safely, landlords must shift from reactive compliance to proactive research. Regularly reviewing City Housing Department updates, maintaining organized documentation, and consulting professionals familiar with local ordinances can prevent costly misunderstandings. Awareness is no longer optional. It is a core part of risk management. When landlords treat local rules with the same seriousness as state laws, they significantly reduce exposure to fines, tenant disputes, and legal complications that often arise from nothing more than regulatory confusion. 6. Tenant privacy and entry notice rules. In 2026, tenant privacy protections are being enforced more aggressively, and many California landlords are underestimating how serious entry and notice violations can become. While landlords still have the legal right to access their property for inspections, repairs, or showings, failing to follow proper notice procedures can quickly escalate into tenant complaints, legal disputes, or even harassment claims. The biggest issue is not intentional misconduct, but casual habits, quick visits, verbal notifications, or assumptions that tenants will be comfortable with last-minute entry. What once felt like routine property management can now be interpreted as a violation of tenant privacy, especially as renters become more aware of their rights and more willing to document incidents. Another growing concern involves repeated entries, poorly timed visits, or unclear communication about the purpose of access. Even when repairs are necessary, tenants may feel their personal space is being disrupted if notice is inconsistent or if entry occurs outside legally acceptable hours. Privacy complaints can also intensify when landlords enter units during disputes, rent negotiations, or maintenance disagreements, as tenants may perceive the timing as pressure or intimidation. These situations can create unnecessary tension and, in some cases, strengthen tenant defenses in broader legal conflicts unrelated to the entry itself. With smartphones and digital communication making documentation easier than ever, small missteps are more likely to become formal complaints rather than informal misunderstandings. The safest approach is maintaining strict consistency with written notices, reasonable entry timing, and clear explanations for every visit. Providing advance communication, respecting tenant schedules when possible, and documenting entry requests can significantly reduce misunderstandings. When landlords treat privacy not just as a legal requirement, but as a trust-building practice, they minimize disputes, preserve positive tenant relationships, and avoid legal complications that often arise from what seems like a minor procedural oversight. Number 5. Habitability and maintenance enforcement. One of the fastest ways California landlords are facing serious financial penalties and tenant lawsuits in 2026 is through habitability and maintenance violations. The definition of a livable rental property has expanded beyond basic functionality, and enforcement is now far less forgiving when repairs are delayed or safety concerns are ignored. Issues like mold, plumbing leaks, heating failures, pest infestations, or electrical hazards are no longer viewed as minor inconveniences. They can quickly become legal claims that allow tenants to withhold rent, request compensation, or involve local housing inspectors. What makes this especially risky is that many habitability disputes don't start with major property damage, but with small maintenance problems that gradually worsen while communication breaks down between landlord and tenant. Another major shift is the speed at which complaints escalate. Tenants today have easier access to reporting channels, legal guidance, and documentation tools, meaning unresolved maintenance requests are more likely to be formally reported rather than tolerated. Once inspectors or legal representatives become involved, landlords may face correction deadlines, fines, and reputational damage that extends beyond a single tenant relationship. Delayed repairs can also create liability exposure if a tenant claims health issues, property damage, or safety risks resulted from neglected maintenance. Even landlords with good intentions can face consequences if repair timelines are unclear, communication is inconsistent, or documentation is missing when disputes arise. The smartest protection strategy is proactive maintenance management. Regular property inspections, clear repair request systems, and documented timelines for addressing issues can prevent small problems from becoming expensive legal conflicts. Prompt communication reassures tenants and demonstrates compliance if disputes occur later. Preventive action is almost always cheaper than reactive legal defense. If you've ever dealt with maintenance complaints or unexpected repair disputes, like this video, subscribe to the channel and comment your experience. Your insight could help other landlords avoid costly mistakes while protecting their investment. Number 4. Security deposit handling violations. Security deposit disputes remain one of the most common reasons California landlords face tenant complaints, financial penalties, and small claims lawsuits. And in 2026, expectations around transparency and timing are even stricter. Many landlords assume deposit handling is straightforward. Collect the funds, deduct damages if necessary, and return the balance. However, problems often arise from incomplete documentation, unclear deductions, or missed deadlines when returning the deposit. Even when deductions are legitimate, tenants may challenge them if they feel the charges were excessive, poorly explained, or unsupported by evidence. What makes this especially risky is that courts often favor detailed documentation, and without clear proof of property condition, landlords can struggle to defend even reasonable claims. Another overlooked issue involves the move-out process itself. Skipping pre-move-out inspections, failing to provide tenants with an opportunity to correct minor issues, or relying solely on verbal agreements can create confusion that leads to disputes after the tenant leaves. Additionally, normal wear and tear versus actual damage remains a frequent point of disagreement. Tenants may view deductions as unfair, while landlords may believe they are simply recovering legitimate repair costs. Without photos, written inspection reports, and itemized statements, these disagreements can quickly escalate into legal challenges that consume time and resources far beyond the value of the deposit itself. The safest approach is consistency and transparency throughout the tenancy. Conducting detailed move-in and move-out inspections, maintaining photo evidence, and providing clear, itemized deduction statements within required timelines significantly reduces conflict. Clear communication about deposit expectations from the beginning of the lease also helps prevent misunderstandings later. When landlords treat deposit handling as a formal, documented process rather than a casual transaction, they protect themselves from unnecessary disputes and create a smoother transition that benefits both parties. Number 3. Eviction justification requirements. Evictions in California have become significantly more complex, with strict just cause requirements and procedural expectations that many landlords underestimate until they are already facing delays or legal challenges. In 2026, simply wanting to regain possession of a property is rarely enough. Landlords must clearly demonstrate legally valid reasons, follow precise notice procedures, and provide supporting documentation that can withstand scrutiny if challenged. The biggest risk is not necessarily the eviction itself, but mistakes made during the process. Incorrect notice wording, improper delivery methods, or insufficient justification can invalidate the entire action. This can force landlords to restart the process, absorb months of lost rent, and potentially face tenant claims of wrongful eviction. Another growing concern is how easily eviction disputes escalate into broader legal conflicts. Tenants who believe they are being unfairly removed may raise defenses related to retaliation, discrimination, habitability complaints, or procedural violations, even if the original eviction reason was legitimate. Courts are increasingly focused on whether landlords followed every compliance step rather than just the underlying cause of the eviction. This means small technical errors can carry significant consequences, including delayed timelines, legal expenses, and additional tenant protections that extend occupancy longer than landlords expected. For property owners relying on rental income to cover mortgages or expenses, these delays can create serious financial strain. The most effective way to reduce eviction risk is careful preparation and documentation long before an eviction becomes necessary. Maintaining written records of lease violations, Payment history, communication attempts, and repair responses can strengthen a landlord's position if enforcement becomes unavoidable. Clear professional communication also reduces misunderstandings that often escalate disputes. Treating eviction as a legal process rather than a property management task helps landlords avoid procedural missteps and ensures that, when action is required, it stands on solid legal ground that minimizes delays and financial exposure. Number 2, tenant harassment and retaliation penalties. A growing number of California landlords are facing serious legal trouble due to expanded definitions of tenant harassment and retaliation, often without realizing their actions could be interpreted that way. In 2026, behavior that once felt like routine property management, frequent reminders about rent, repeated inspection requests, pressure during disputes, or changes in communication tone, can sometimes be viewed as intimidation or retaliation if tenants believe their rights are being challenged. The risk becomes even higher when conflicts arise after tenants file complaints, request repairs, or question lease terms. Any negative action taken shortly afterward, such as rent increases, eviction notices, or reduced services, may be perceived as retaliatory, and even if the landlord had legitimate reasons. Another major issue is the emotional aspect of landlord-tenant conflicts. Frustration, urgency, or financial stress can lead landlords to communicate in ways that unintentionally escalate tensions. Messages that feel direct or firm from a landlord's perspective may be interpreted as threatening or coercive by tenants, especially when disputes are already ongoing. With digital communication creating permanent records, texts, emails, or voice messages can become evidence in harassment claims, turning simple disagreements into legal challenges. Repeated property visits, sudden policy changes, or attempts to pressure tenants into moving out voluntarily can also strengthen allegations, increasing the likelihood of complaints and potential financial penalties. Preventing harassment and retaliation claims requires consistency, professionalism, and careful timing of landlord actions. Maintaining respectful communication, documenting legitimate reasons for decisions, and allowing neutral time gaps between tenant complaints and enforcement actions can significantly reduce misunderstandings. It is equally important to respond to tenant concerns promptly and fairly, as unresolved issues often fuel perceptions of retaliation. When landlords approach disputes with patience, transparency, and documentation, they not only protect themselves legally, but also create a more stable and cooperative rental environment that reduces the likelihood of conflicts escalating into costly legal battles. Number 1. Rent increase restrictions. Tightened. One of the most impactful changes affecting California landlords is the tightening of rent increase restrictions and justification requirements, creating financial pressure for property owners who rely on rental adjustments to keep up with rising expenses. In 2026, rent control enforcement and tenant protection policies are being applied more carefully, and increases that once seemed reasonable may now trigger tenant complaints, regulatory scrutiny, or legal disputes if proper procedures are not followed. Many landlords underestimate how strict notice timelines, percentage limitations, and exemption rules can be, especially when managing older properties or units located in rent-controlled jurisdictions. And even landlords who believe their property is exempt may face complications if they fail to provide required disclosures or misunderstand how local regulations interact with state-level protections. Another growing challenge involves the perception of fairness. Sudden or poorly explained rent increases can lead to tenant resistance, formal complaints, or increased scrutiny of other aspects of the tenancy. Tenants today are more informed about their rights, and advocacy groups actively educate renters on identifying improper increases or procedural mistakes. This means landlords not only need to comply with numerical limits, but also ensure that communication is clear, timely, and legally accurate. Failure to follow correct notice formats, provide adequate timing, or respect local ordinances can invalidate an increase entirely, forcing landlords to absorb financial losses and potentially face penalties if overcharges occur. The safest approach is careful planning before implementing any rent adjustment. Understanding applicable caps, verifying exemption status, Maintaining proper documentation and communicating transparently with tenants can prevent disputes before they arise. When landlords treat rent increases as a compliance process rather than a financial decision alone, they reduce legal exposure, preserve tenant relationships, and maintain more predictable rental income in an increasingly regulated housing environment. California's rental landscape is changing fast, and as you've seen, small mistakes can now lead to massive financial consequences for landlords. From rent increase limits to privacy rules and lawsuit exposure, staying informed is no longer optional. It's essential for protecting your property, income, and long-term investment. The landlords who succeed in this environment are the ones who stay proactive, organized, and legally aware before problems begin. If you found this helpful, like this video, subscribe to the channel, and comment which rule surprised you the most. Also, watch our next landlord survival guide. It could save you from your next costly mistake.